Good morning, everyone. Today we are going to talk about intellectual properties, or better known as IP. What is IP? IP is intellectual properties that refers to creation of minds, inventions, literally, and artistic works, symbols, names, images, and designs used in commerce. So there's a few frequently asked questions about IP. For examples, can the innovation be legally protected? And for how long? How does one protect an invention from imitators? How much will it cost? When to protect? Do you need to rely on IP expert? Right. The answers are complicated by the fact that one or more types of legal frameworks may be used to protect a particular innovations, products, process, or creative works. These include trade secrets, trademarks, designs, patents, and copyrights. So it is necessary to know which are applicable and when each appropriate. This varies somewhat from jurisdiction to jurisdictions, meaning from country to country, and the advice of a lawyer or the legal expert that specialize in these matters is essential. Right. Why protect an ideas? Legal protection of your ideas or inventions ensure that future position of your company, your brand, and enables you to make money in a highly competitive marketplace. You also need to protect your ideas because it can stop others from copying your ideas, allowing you to maximize the return you deserve for investing your time producing the products, and also your capitals and resources in the invention of that particular ideas. Why should we care about IPs? So we need to listen to an expert. So please look at this video.
What is intellectual property and why do I care is something that I get asked all the time. After I finish explaining what intellectual property is, a lot of people just right away they say, hey, I've got ideas, but I don't have any intellectual property. So intellectual property is more than ideas. Intellectual property is trademarks, copyrights, trade secrets, and patents. Most people have heard of patents, but just an idea by itself is not a patent, is not a trademark, is not a copyright. Your ideas might be secrets, so you need to keep them secret until you can figure out what they are. So why do you care? Because companies' values, projects' values, inventions' values are in that intellectual property. Most companies in the US and the EU have almost half of their value. So if you look at something like Coca-Cola, their market value is $100 billion. But then if you looked on their actual hard assets on their balance sheet, what they actually have paid for, owned, sitting right there on their balance sheet, that's about 40 billion. That difference is their brand, their trademarks, their goodwill, their intangibles. It's their intellectual property. So that's why you should care about intellectual property, because it is very, very valuable. So what you need to do is you need to figure out what your intellectual property is so you don't lose it. We have lots of examples of people toiling away. You might work for company X and on the side you're coming up with this great idea, this great invention, only to find out later, oh wait, I don't own that. I actually signed an employment contract with company X that said that anything that I invented, they owned. So people will lose their intellectual property if they don't understand what it is. And so you need to care because You don't want to lose something that you work for a couple of years on. The other side is you need to know what intellectual property is because you might be accidentally infringing on someone else's intellectual property. For example, you create a crowdfunding campaign, you go out and you grab a song off the internet and you've put it in the background of your video. Cool video. Potential infringement suit. And if you grab clips from movies, for those of you who watch right at the end, there is a basic warning that tells you that a copyright violation, if you're charged, is $250,000 a violation. Nobody wants to do that. So you need to make sure that you understand intellectual property, because it's not just Apple and Samsung who are arguing over this. It's in everybody's business. So make sure that you know what intellectual property is and get informed so that you can keep your company's value.
So what the intellectual properties is? So intellectual properties is a legal concept. Copyright, trademark, and geographic indication, patent, trade secret, plant varieties, and so on is a legal concept. Intellectual properties also a social construct that defines intangible borders as opposed to the tangible borders, real property borders. Intellectual property also a business asset that can be valued and traded. You actually can sell your IP. Intellectual property also an instrument to achieve humanitarian objectives. And intellectual property also a policy tool to foster investment in innovations. So if you did not protect your IPs, you can see by looking at this picture, there's a lot of imitation goods in the products. So if you did not protect your creations, it will become like one of these. The fake is a new real. Right. Now, we want to talk about the intellectual properties as a tool for development. As mentioned by WIPO, WIPO, or the World International Properties Organizations, which is in Geneva. So they say in the age of the knowledge economy, the efficient and the creative use of knowledge is a key determinant of international competitiveness, which wealth creation and improve social welfare. And also, an effective intellectual property system embedded within a national strategy which anchors IP considerations firmly within the policy-making process, which help a nation to promote and protect its intellectual assets, thereby driving economic growth and wealth creations. This is said by Kamal Idris, the Director General of WIPO. And in Malaysia, IPs is organized by MyIPO. Right. So now we look at the type of IP rights. It's a trade secret, copyright and related rights, industrial designs, trademarks, which mean brands, geographical indications, utility models and patents, new varieties of plants, this is specifically for agro-industry or biotechnology, unfair competitions. This is quite rare, but it's necessary. We look at one by one. So now we look at trade secret. So what is trade secret? So trade secret is any confidential business information which provides an enterprise a competitive edge, may be considered a trade secret. So the subject matter of trade secrets is usually defined in a broad terms and includes sales, methods, distribution methods, consumer profiles, or even recipes for the case of KFC, McDonald's, and so on, and also advertisement strategies, list of suppliers and clients is maybe secret, and you want to protect it, and also maybe it could be manufacturing process. So a company like Coca-Cola, Energy 5, WD-40 is protect their product through trade secrets. Those trade secrets encompass manufacturing or industrial secret and commercial secrets. Now we look at trademark. This is a very common one. So what is actually trademarks? Trademark is a trademark or design or sign which distinguishes its goods and services from one trader to another. A mark includes the words. If you look at the Intel inside, Microsoft, Coca-Cola, they have a very distinctive word that use their colors, their pictures, their features, their design of the letters, the numbers, or the combination of all those. So this used as a marketing tools to enable consumers to recognize these products, and also for the particular traders to be known as it is. Right? So the example you can see everywhere. So the product must have its own trademark. If not, people won't know that it's their product. So what is the function of the trademark? So the origin of the function is to help to identify the source and those responsible for the products and service sold in the market. And then you have the choice functions. So what is the choice function of the trademark? So trademark enable consumers to choose between the goods and services with ease while shopping. So if you see there's a Coca-Cola and also Pepsi, so you know straight away which one you want to choose by just looking at their trademark. And trademark also function as marketing tools. So trademark play an important role in advertising. It's normal for consumer to make purchases based on continuous influence of advertising. So for example, Coca-Cola and Apple's always continue making new advertisements using their trademark. And also trademark has economic functions, which established trademark is a valuable asset. So this trademark may be licensed or franchise. So if you have a franchise business, the trademark has to be the same as the mother company. So well-known examples is apple. So if you look at the picture of an apple or the figure of an apple with a bite mark and one leaf on top, you know straight away there is a apple. So it's a registered trademark. So the name Apple, A-P-P-L-E, and the logo above, if you can see, are example of some of the registered trademark the company holds. Apple holds approximately 8,000 registered trademarks. So one product can have several trademarks. Alright. So if you have a trademark for your own products, you need to register them. So you can put R registered trademark next to your logo or your name or whatever the figure that you use for trademark. So the trademark registration provide for one is exclusive rights. So registered trademarks, owners have exclusive rights to use their mark in trading, right? So they also have the right to take legal actions for infringement under the trademark law against others to use their trademark, okay, without consent. So they can either take civil actions or lodge a complaint to enforcement division for appropriate action under the Trade Description Act 1972 in the Malaysian Trademark Act, right? And also, the trademark have to be registered for legal evidence. So the registration certificate issued by Registrar Office is a prima facie evidence for trademark ownerships. So if you don't register, you don't have the ownership of the trademark. So a certificate of registration serves as an important document to establish the ownership of goods exported to other countries. Okay, now we look at another protection for IP, which is geographical indications. So what is geographical indications? So geographical indications, or often known as GI, is a sign used on products that have a specific geographical origins and process qualities for a reputations that are due to that origins, right? So the quality of the product is specifically referred to the region. All right. So in order to function as a GI, a sign must identify a product as originating in a given place. In addition, qualities, characteristics, or reputations of the product should be essentially due to the place of origin. Since the qualities depends on the geographical place of productions, there is a clear link between the product and its original place of productions. There may be a history behind, there may be somebody from that region that produced that kind of product. So there must be a clear link between the product and the place of the production. So that only we can call it geographical indications. So for example, you have Darjeeling tea. So you have Cornish pasry, that is used from Cornish, and also for Malaysian you have Terengganu Kopo Lekor, who is originally from Terengganu, and everybody knows if the Kopo Lekor from Terengganu has a very distinct taste. So next we look at copyright. So what is copyright? So copyright is an exclusive right given to the owner of a copyright for a specific period. Copyright protection in Malaysia is governed by the Copyright Act 1987. Right. There is no system of registration for copyright in Malaysia yet, and a work that is eligible protected under the copyright must fulfill the following conditions. So first one, sufficient effort has been expected to make the work originally in characters. So the work has been written down, recorded, or produced in a material form. It's not just an idea, it's not just in the head, but it's already written and transformed or recorded in some form. It's material form. And also, the author of the copyright is qualified person of that particular work. If it's Malaysia, it's made in Malaysia, or what is first published in Malaysia. So what are the works that are eligible for the copyright protections? So it's involved literary work, musical work, artistic work, films, sounds, recordings, broadcasting, or derivative works, and also computer programs. For example, Apple, if you can see, if you have an iPhone or any other products, you may see there's a indication there, copyright for what time, what year, and what company. So for example, for Apple, copyright Apple 4, copyright 2012, by Apple Inc. and all right reserved to the Apple Inc. corporations. We look at industrial design. What is industrial design? Industrial design is the ornamental or aesthetic aspect of an article. The design may consist of a three-dimensional features such as the shape of the configuration of an article, or two-dimensional features such as pattern and ornamentations. The design features must be applied to an article by any industrial process or means of which the features in the finished article appeal to eye. So, what right does a registered design confer? Right? So, a registered design confers the owner of registered design the exclusive right to make, import, or sell, or hire out of any article to which the design has been applied. Other users should obtain the permission or consent of the rightful owner before using the design. The owner of registered design has the right to take legal actions if any party or anybody use that particular design without their consent. Now, we look at patents. What is patent? Patents is the most popular IPs, right? So what is actually patent means? Patent is an exclusive right granted for an invention, which is a product or process that provides a new way of doing something or offers a new technical solution to a problem. Beside patents, there's also a utility innovations, which is the extension of the original patents. So what is utility innovations? So utility innovation is an exclusive right granted for a minor inventions which does not require to satisfy the test of inventiveness as required for a patent. Right. So why you have to protect the patents? Alright, so patent or utility innovations protection gives the owner the patent utility or utility innovations the exclusive right from manufacturing, using, or selling the owner's inventions. In Malaysia, if its case is patents in Malaysia, so its case in Malaysia is important worldwide, so you can use or sell or have the right throughout the world. And it must have the consent if anybody else want to use that particular patents. So why are patents awarded? So the patent is actually an incentive to invest in the innovations. So in a way of producing an innovations, so an invention may occur without monetary incentive due to human curiosity and others, but an innovations or invention requires investment. So patents that awarded to the inventors is actually an incentive for the investment in the innovations. So patents balance the need to provide incentive with the introduction of the market failure, for example, the high price of non-rival goods. Right? So have patent protection for up to 20 years, then the knowledge or innovation can be exploited by everybody that's involved in the creating the innovations. Right. Here you can see that the top patentees at UN Patent Office and European Patent Office. So if you can see that IBM throughout in the US Patent Office have the highest patent granted in 2006 compared to Philips in the European Patent Office. So it's different from country to country. Right. For patents, the legal aspect for patent is a monopoly right lasting up to 20 years from filing. So the legal aspect of patent also disclose your idea to the public, and also it's country specific. So if you file in Malaysia, it might not applicable to in Thailand, for example, right? So the patent paper aspect is actually a description of a technical ideas, a definition of what cannot be done by others, or the names of the inventors. So in patent, there's also a social bargains. So the state grants a monopoly right, but you disclose your idea to the world. Means you protect but you disclose, so people will know what you are doing and so on. So the exclusivity in a defined technical area. So chance to recoup with your invention. So it gives you a chance to recoup with your investment. So in return, you pay some fees to the state, and hopefully it will stimulate some others innovations. So what are the innovations or inventions that are patentable? It's nearly anything technical can be patented. For example, products. It could be molecules, it could be materials, it could be new compositions. For apparatus, it could be for making the apparatus, it could be purifying, it could be extracting, and anything else. For methods, it could be synthetic methodology, it could be process step, it could be treatments, and so on. For users, it could be used as a drug, used as a pain, used as anything else that you can think of. But it must be new, which is novel. It's not obvious, which is involved and inventive steps. It's not just a common step or methods. And also capable of industrial applications. So if you have a very innovative products, but it's not useful in the industrial application, it's not patented, right? So now we look at what is the mean of novelty and disclosure. So anything that made available, you mean disclosed to the public anywhere. For example, the prior arts. So you can find anything during the prior arts. Published document, posters or lectures, that means you disclose your inventions. So in order to anticipate the claim of all features must be in a single document, lecture or posters. If you want a little bit of the disclosure in various forms, is not considered as a disclosure. So disclosure of an invention, so the invention must not have been made available to the public in any way, anytime, anywhere, because this is very important. If you already disclose your products or your invention, you cannot be patent your products. So this can be gathered against tough imposing a CDA that we call it. So for example, Apple holds approximately 5,400 patents covering all of the technical aspects of its products. Right, just now we're talking about an intellectual properties in a general terms. Now we're looking at the intellectual property right that is close related to the agriculture and also biotech. So we call it agri-biotechs. There are two IPR that currently available for agri-biotechs. The first one is the right in the plant varieties, or sometimes we call it plant breeder rights. And the second one is a patent. So plant varieties is the main IPR for agricultures. So it started in the mid-1960s when a few countries, for example Germans and US, gave the right to the plant protections because of the pressure from the plant breeders industries. Alright, so there's an International Union for Protection of New Plant Varieties, short terms UPOV, UPOV, was formed in 1961. So initially, UPOV gives protection to at least 24 genera or plant species protections. But then from 1991, all genera and species can be protected under the plant varieties. So what is the items that fall under plant varieties? The plant varieties is protected under UPOV if it is a distinct, is a new one, uniform and stable. So we call it DUS, and satisfies a novelty requirement. Novelty and inventiveness are more leniently to novelty under patent law, but are more lenient applied in comparison to patent rules. So satisfaction of the DUS criteria is conducted by the national authorities responsible, usually by growing the varieties over at least 2 seasons. So if you have a plant varieties but only can be grown only one round or one season, is cannot be protected under plant varieties. There are also an important requirement that the variety be maintained throughout the duration of the protections. Is, for example, if the protection is last for 20 years, so the varieties of the new varieties has to be maintained throughout that 20 or 30 years. So the granted of plant varieties right confers an exclusive right on the holders, including first, the exclusive right to sell the productive materials, for example seed, cutting or the whole plants. The second one, the exclusive right to the holder of the plant varieties to the harvested materials. Alright, so the third one, the plant varieties holders have the right to the enforcement right against farm safe seeds. This is a very controversial because the farmers like to produce their own seeds for the future season, but under this protection they cannot save the seeds from their plants. And the right do not extend the consumption material, and the right do not extend to the consumption material, for example fruits, seed grown for milling flour and so on. Alright, so next we go look at the patent for biotechnology. Initially, only a few countries provide protection for biotechnology, such as Australia, Bulgaria, Canada and Hungary. The reason may be different, but generally, because biotech has been thought inappropriate for patent protection, because either the system designed for mechanical inventions or for the technical or practical reason, or for the ethical, religious or social concerns. Grant of patent for biotechnology rights confers exclusive rights same as other patents. There are 3 international IP treaties that which are important for the protection of the biotechnology. Right, the first one is the Paris Convention for the Protection of Industrial Properties, or we call it the Paris Conventions. The second one is the Budapest Treaty on the international recognition of the deposit of microorganisms for the purpose of patent procedure, or we call it the Deposit Treaty. And the last one is the important international treaties for biotechnology protection is the Patent Cooperation Treaties, or in short we call it PCT. So in the Paris Convention, is originally signed in 1883 by just 11 countries, but now the majority of the countries in the world who have any form of intellectual properties law are part of it. Okay, the keystone to this convention is the principle of national treatment. An applicant from one convention countries shall have the same right in the second convention countries as a national of that second country. So the convention covers patents and define them so broadly that it permits applications to any of the form of industrial patents granted under the law of the convention's countries. So the most important practical result of this convention is that it is possible to claim priority for an application made in a convention countries to all subsequent countries within 12 months of original patent filings. Alright, now we look at what is the deposit treaties. The deposit treaties is concerned with the deposit of an example of microorganism for the purpose of patent applications. So the application for patents for biotechnology often face considerable difficulties in describing the nature of the invention sufficiently. So the deposit treaty is a vehicle for solving these problems, primarily through the setting up of the series of international deposit authorities, or IDA, and through the recognition by all member countries of a deposit in a single IDA. So now we look at what is PCT. The PCT simplifies the process of filing patents applications simultaneously in a number of countries. Under the PCT, a single application may be filed in one of the official receiving offices, designating any numbers of PCT member countries, which can be eventually result in a national patent being granted in each of the designated countries. A prior art search is performed by the receiving office and a report sent to the applicant. So the application and reports are published, and the publication will then move one either to an international preliminary examinations followed by national examination, or alternatively straight to the national examination stage. So it makes patent application more simpler. Okay, we're done for all of our lectures. Now try to answer some of these questions. Define intellectual property rights and list the type of protection covered by these rights. Second question, what are two main systems in IP protection for biotechnology? The third question, there are international intellectual property treaties that are important for biotechnology protections. Describe those treaties and briefly explain their roles with regard to safeguard biotechnology invention. With that, thank you. Happy listening.